everyone, I am Dr. Shruti Nadkarni, Assistant Professor in Law. In continuation with my series Law and You, I am here with yet another video. Today's video is going to be on the topic Introduction to Intellectual Property Rights, that is IPR. In this video, I am going to briefly explain about various kinds of intellectual property rights. So let us begin.
What is intellectual property? Intellectual property is creation of human intellect. Anything that is created by human beings, such as inventions, literary and artistic works, designs and symbols, names and images which are used in commerce, can be considered as intellectual property. So we can say that it is original creative work manifested in tangible form that can be legally protected. Now let us see what are intellectual property rights. The rights guaranteed by law to creator of intellectual property are called intellectual property rights. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Intellectual property rights can be classified into various categories. There are two main categories, those are copyrights and rights over industrial property. Rights over industrial property can be further classified into patent, trademark, rights over industrial designs, trade secrets and geographical indication. Now let us discuss each IPR in detail. First right is copyright. Copyright is a legal term used to describe the right that creators have over original literary, dramatic, musical and artistic work, cinematograph film and sound recording. Remember, there is no copyright in ideas. Works covered by copyright range from books, music, paintings, sculptures, films to computer program, databases, advertisement, maps, technical drawings and so on. Copyright subsists in the work of a creator during his lifetime and 60 years thereafter. The legal regime relating to copyright in India is governed by the Copyright Act 1957. This act has been amended 5 times, the latest being in 2012. The responsibility of implementing Copyright Act is given to Copyright Office established under the Act. This office is under the control of Registrar of Copyrights. Once the copyright is registered, the names, titles of work or the addresses of the authors, publishers and owner of copyright and other particulars is entered in Register of Copyrights, which is kept in Copyright Office. Copyright is available to the creator or author as soon as the work is created by him and it is given a material form. Registration of copyright is optional. However, registration raises a presumption in respect to particulars in the Register of Copyright, which becomes an important source in case of infringement of copyright. Copyright guarantees several rights to the author of the copyright. Copyright means the exclusive right to do or authorize the doing of certain acts in respect of the work created by the author. The author has right to reproduce the work in any material form, including the storing of it in any medium by electronic means. He can issue copies of the work to the public. He can perform the work in public. The author can make any cinematograph film or sound recording in respect of the work created by him. He can make any translation of the work. He can make adaptations of the work. He can sell computer programs or give it on commercial rental. He can also make copies of the cinematograph film created by him. If any person uses the exclusive rights available to owner of the copyright without his permission or without valid license from Registrar of Copyright, it amounts to infringement of copyright. In such cases, the owner or the author of copyright can file a civil suit claiming injunction, compensation, or account of profits. Now let us discuss some of the examples of copyright infringement in India. The first example is a case between filmmaker Sunil Darshan and Google India. Filmmaker Sunil Darshan, the proprietor of film production company Shri Krishna International, filed a suit for permanent injunction against Google India and its YouTube video streaming platform and their US parent company. His contention was that the defendants had infringed his copyright in respect of sound recording, cinematograph film, and audiovisual song by streaming them without any license or authorization from him. After a long battle of 8 years, the court awarded damages of rupees 50,000 to Sunil Darshan and restrained Google and YouTube from infringing his work. The next example is an interesting one, the Genda Phul controversy. It is related to the popular song of rapper Badshah titled Genda Phul. It was alleged that Badshah copied the part of this song from Bengali folk song Boro Lokar Bitilo, which was originally written by singer Ratan Kahar in 1972. However, Badshah was credited with the composition and lyrics of this song. To end this controversy, Badshah gave credit to the original lyricist and also paid him monetary compensation. Now let us move on to the second category, that is rights relating to industrial property. The first and the most important among these rights is patent. Patent is an exclusive right granted for an invention. It provides the patent owner with a right to decide how or whether the invention can be used by others. Patent is granted to an invention which has following properties. The invention should be novel, that is, it should be new. Secondly, it should have inventive step, that means it should be non-obvious. And thirdly, it should be capable of industrial application. That means it should be useful and must be capable of being manufactured commercially. Once the patent is granted, the patent owner makes the technical information about the invention publicly available in the published patent document. The patent is granted for 20 years from the date of application for grant of patent. The legal regime relating to patents in India is governed by the Patents Act of 1970, which is amended in 2005, and the Patent Rule of 2003. The Patent Act 1970 prohibits certain inventions from being patented. These are called as non-patentable inventions. Now let us discuss these non-patentable inventions. The first one are the frivolous inventions. These are misleading or trivial inventions. For example, invention claiming teleporting or invention claiming to produce 100% efficiency, these cannot be patented. Secondly, inventions which are contrary to law or morality or injurious to public health, these cannot be patented. For example, invention to hack into somebody's computer system or device for housebreaking cannot be patented. Thirdly, mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature cannot be patented. For example, natural gas or some chemical element occurring in nature cannot be patented. Fourthly, the mere discovery of a new form of a known substance cannot be patented. For example, liquid or a crystalline form of an already known substance will not be able to be patented. However, salts or ethers, pure forms, isomers, combinations of these known substances, if they show enhanced efficacy, they will be entitled to be patented. Similarly, a substance obtained by a mere admixture of already existing substances cannot be patented. For example, mixing sugar plus water, sugar solution that is obtained cannot be patented. Mere arrangement or rearrangement of known devices cannot be patented. For example, attaching torch to an umbrella or a clock to a radio, where both these elements are doing their independent work. This arrangement cannot be patented. Similarly, method of agriculture or horticulture cannot be patented. For example, method of cultivation or a new type of soil cannot be patented. Any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings or animals to render them free of disease or to increase the economic value of themselves or their products will not be able to be patented. However, apparatus used for these purposes could be patented. Plants, animals in whole or any part of these plants or animals other than microorganisms cannot be patented. For example, clones of animals can't be patented. A mathematical or a business method or a computer program per se or algorithms cannot be patented. For example, methods to solve crosswords cannot be patented. One thing to be noted here is that computer programs per se can get protection under Copyright Act. Similarly, a literary, dramatic, musical or artistic work cannot be patented because even these works will be protected by copyright. A mere scheme or rule or method of performing mental act or method of playing games is also a non-patentable invention. Presentation of information in tabular form or a peculiar arrangement also cannot be patented. Topography of integrated circuits cannot be patented. However, these integrated circuits will be protected under the Semiconductor Integrated Circuits and Layout Designs Act 2000. An invention which in fact is a traditional knowledge in India cannot be patented. For example, usage of turmeric, neem or like substances which are in traditional knowledge in India cannot be patented. And finally, an invention relating to atomic energy falling within the Atomic Energy Act 1962 is also prohibited from being patented. Now let us move on to how to obtain patent. For obtaining patent, application for grant of patent has to be made by true and first inventor of the invention or his assignee or licensee. This application will have to be made to Registrar of Patent, who is an authority constituted under the Patent Act for this purpose. The Registrar of Patent will scrutinize and assess this application following the procedure laid down under the Act, and if the patent is granted, the details of the patentee and the patent is entered into Register of Patents, which is kept in the Patent Office. Since patent is a very important intellectual property rights, the grant of patent is opposed on various counts in number of cases. Let us discuss two such popular cases. The first one is turmeric patent case. In 1995, the US Patent Office granted patent to a US company for use of turmeric in wound healing. As you all know, turmeric has been used for wound healing in India from a long time. The Indian organization, Council for Scientific and Industrial Research objected to grant of this patent. They produced evidences that using turmeric for wound healing is an age-old practice in India, and therefore it is within the traditional knowledge of India. The US Patent Office was satisfied with these evidences, and they agreed that claims made by the US company were obvious and use of turmeric for wound healing is an age-old practice in India, and therefore it comes within the traditional knowledge belonging to India. And they revoked the patent that was granted to US company for use of turmeric for wound healing. The second example is Basmati rice patent case. In 1997, American company Ricetech Inc. was granted patent by US Patent Office for a novel grain also known as Basmati. India opposed the grant of this patent and contended that 75% of the rice in United States was imported from countries like India, Pakistan and Thailand. And therefore, since this rice cannot be grown in America, the strain of rice for which the patent is claimed cannot be novel, it is obvious in nature, and therefore patent should be null and void. After a long battle of 3 years, India produced the evidences and proved that this patent has to be declared null and void. Finally, out of 20 claims made by the company, the US Patent Office granted only 3 claims on the grounds that there was noticeable difference in the starch index of these particular grains as compared to basmati grains in India. However, they disallowed the use of term basmati for the product of Ricetech company. Now let us move on to the next intellectual property right for industrial properties, the trademark. A trademark is a sign which is capable of distinguishing goods or services of one person from that of another. Trademark can be a word, phrase, symbol, design which identifies and distinguishes the source of the good of one party from that of others. We have seen several trademarks on day-to-day basis. For example, McDonald's, Apple, Amazon, Nike. A trademark which identifies a service or a service provider rather than a product is called as service mark. For example, the trademark of Amazon or LinkedIn, these are called as service marks. Trademarks are designated by various symbols. A trademark which is in the process of being registered is usually designated by a symbol TM. However, when it is service mark which is in the process of registration, the symbol that is used is SM. Once the trademark is registered, the company can use a symbol R next to its logo. This depicts that the trademark has been duly registered and is protected under Trademarks Act of 1999. Once the trademark is registered, it is valid for a period of 10 years from the date of application. After that, the registration can be renewed for 10 years at a time after paying renewal fees. The trademark is registered under the Trademarks Act 1999. The Registry of Trademark registers it. The registration of trademark gives several advantages to the proprietor. It protects the goodwill in the business. It protects name or brand name from being misused by any other business firm. Registration creates an impression on the customers that the company is selling some standard products or services. It also gives exclusive right to the proprietor to use the trademark in relation to the goods or services in respect of which trademark is registered. Registration also gives a right to obtain relief in case of infringement of trademark by any other person. It also gives the proprietor power to assign or transfer the trademark to another for consideration. Now let us see what do you mean by infringement of trademark. Using a trademark which is identical or deceptively similar, which is likely to cause confusion in the minds of the public as to the original product, thereby taking unfair advantage of reputation of the registered trademark, is called as infringement. In case of trademark infringement, the registered proprietor can bring an action against the violator by filing a suit for infringement in the court. Let us discuss some of these cases for infringement. The first case is Louis Vuitton versus Louis Vuitton Duck. In this case, Louis Vuitton Duck, a South Korean fried chicken restaurant, copied the logo of clothing designer Louis Vuitton. The designer filed a suit for infringement against the restaurant owner. The court ruled the case in designer's favor, concluding that the restaurant's name, Louis Vuitton Duck, was too similar to the brand name Louis Vuitton. Also, the logo and the packaging of the restaurant were resembling very much to the designer's iconic image, as you can see on the screen. In the second case, Amul Dairy, or as it is also known as Kare District Cooperative Milk Producers Union, and the Gujarat Cooperative Milk Marketing Federation, filed trademark infringement cases against two local shop owners in Gujarat. They contended that these shop owners used the brand name Amul for their shops, namely Amul Chashmaghar and Amul Katpi stores. The district court restrained the two from using Amul trademark for their shops and their business, and the same order was upheld by the High Court of Gujarat. The court held that even if the company is selling goods other than the sold by the registered proprietor, the company cannot use the registered trademark of the other registered proprietor. Thus, the court ruled that registered trademark user has a right to restrict others from using their trademark for different class or goods. The third case is Starbucks Coffee versus Sardar Bucks Coffee and Company. Starbucks is a well-known coffee joint having distinct trademark. In 2015, a coffee place was started in Delhi called as Sardar Bucks Coffee and Company. Starbucks filed a suit for infringement of their trademark against Sardar Bucks Coffee and Company, contending that the logo of Sardar Bucks Coffee and Company as well as the name was similar to that of Starbucks. Sardar Bucks Coffee and Company was asked by court to change their logo. They had to change the color of their logo to yellow and black, and also they were asked to change the name to Sardarji Bucks Coffee and Company. The fourth case is relating to deceptively similar trademarks. Parle Agro Private Limited versus Walmart India Private Limited. Parle Agro Private Limited sued multinational retail company Walmart India Private Limited for violating its trademark by launching a drink called Fizzy Apple. The packaging of the bottle of Fizzy Apple, label and the logo was deceptively similar to the packaging label of the drink Appy Fizz belonging to Parle. Court granted interim injunction restraining Walmart company from retailing the product. Subsequently, the Walmart company gave undertaking to the court that they will not use the label similar to that of Appy Fizz. Now let us come to the next intellectual property right, geographical indications. Geographical indications are signs used on goods that have specific geographical origin, and they possess qualities, reputation or characteristics that are attributable to the place of their origin. Geographical indications can be obtained only in case of agricultural, natural or manufactured goods or goods of handicraft and includes foodstuff. It is governed by the Geographical Indications Registration and Protection Act of 1999 and the Geographical Indications Registration and Protection of Goods Rules 2002. Geographical indication prevent use by third person whose product does not conform to the applicable standards. However, a protected geographical indication does not enable the holder to prevent someone from making a product using the same techniques as set out in the standard for that indication. The first product to get geographical indication in India in 2004-2005 was Darjeeling tea. Since then, more than 400 plus products have got geographical indication tags as of March 2023. The Gond art of Madhya Pradesh, Nagari Dubraj rice of Chhattisgarh, Mircha rice of Bihar, and Banarsi pan of Uttar Pradesh have been added to the list recently. Here are some of the examples of geographical indications which are famous in India, like Darjeeling tea, Kanchipuram silk, Alfonso mango, Nagpur orange, Kolhapuri chappals, Bikaneri bhujia, Agra petha, Goa feni, Palkadan matta, Navra rice, and so on and so forth. The next intellectual property that we are going to discuss is industrial design. An industrial design constitutes the ornamental or aesthetic aspect of an article. Industrial design may consist of 3D or 2D shape. It may consist of patterns, colors, lines, textures on a particular product. The industrial designs are governed by the Designs Act 2000 and corresponding Designs Rule of 2001. For example, shape of a car or a mobile phone or cold drink bottles, the texture on the bottles, a peculiar color given to a particular product, the lines, patterns, these all constitute industrial designs. The last intellectual property is trade secrets. Trade secrets are intellectual property rights on a confidential information relating to a product, which can be sold or licensed. The unauthorized acquisition of this information or use or disclosure of the secret information in any manner will be contrary to honest commercial practices by others, and it is regarded as an unfair practice and violation of trade secret protection. Trade secrets are protected under the Contract Act of 1872. Some of the famous trade secrets involve the formula of Coca-Cola or recipe of KFC chicken or the recipe of McDonald's Big Mac special sauce or the formula of WD-40 oil. So, after discussing copyrights and the intellectual property rights relating to industrial property, it must be very clear that intellectual property and the rights relating to them are something that we come across in our day-to-day life. If you take a simple example of a car, the intellectual properties relating to that car and the rights and the law protecting those intellectual property are several. For example, the shape of the car is protected by industrial designs. The logo of the car, the branding can be protected as a trademark. The technology that is involved in the car can be protected by patent. The manual that comes along with the car, that can be protected by copyright, and so on. So, in this video, we have covered various kinds of intellectual properties and rights in relation to these intellectual properties. We have also discussed the provisions of law that governs each individual type of intellectual property in India.
So, I hope this video must have helped you understand various kinds of intellectual property rights. Please give your feedback in the comment section about this video. Also, if you have any particular topic on which you want me to make video, please leave a comment below. See you next time.